Hello, I'm Professor Kozlowski. Welcome to my webpage here at George Mason University. You see a list of courses I teach, most of which are online televideo courses. And the readings in many of these courses are taken from articles I've written for the Parks and Recreation magazine, which is the official publication of the National Recreation Park Association. I started writing this monthly law review column in January of 1982. And there's a link on my webpage to an archive of most of these articles. And today we'll be reviewing an article that appeared in April of 2012 titled Hidden Drowning Danger at Riverside Park Dam. This particular article opens with a description of general principles governing landowner liability and notes that generally there's no legal duty to warn invitees, those who are encouraged to be on the premises for a particular purpose, no duty to warn of open and obvious natural hazards, which would include the risk of drowning in a natural body of water that's not designated for swimming. In fact, the risk of drowning in a natural body of water not designated for swimming is considered open and obvious to anyone old enough to be at large. However, as illustrated by this particular case, there may be a legal duty to warn, particularly where swimming is encouraged in the area and there exist, beyond the open and obvious risks associated with water, a danger which is hidden or unusual, an effective man trap which would not be apparent through the use of one's senses. In addition, this case illustrates a type of statutory immunity specific to the Commonwealth of Virginia, and it's typical of many of these kinds of statutes that provide limited statutory immunity for park and recreation agencies, either under the State Tort Claims Act, which defines under what circumstances the government will be liable, a public recreation immunity statute, which we'll see an example here from Commonwealth of Virginia, and or sometimes both statutes might apply, a state recreational use statute. And typically these statutes, limited immunity statutes, accomplish the same purpose, whereby there won't be landowner liability for ordinary negligence. If the statute applies, injured party has to show proof of gross negligence or willful wanton misconduct to impose liability. The Commonwealth of Virginia, Section 15.2-1809, provides localities immunity from liability for ordinary negligence in typical of these statutes, but there's no immunity for liability from gross negligence for such cities or towns in the operation of parks, recreational facilities, and playgrounds. We've got the statute quoted here, so there's no liability for ordinary negligence, cities, towns, in the operation of a recreational facility or playground when the ordinary negligence involves the maintenance or operation of such park, recreational facility, or playground. However, there will be liability where there's gross negligence in, once again, the maintenance and operation of a park, playground, facility. While it mentioned cities or towns, the statute was later amended to include counties, and there have been reported cases from lower courts that have extended this immunity to the park authorities in Northern Virginia. So let's take a look at the case that we're looking at today, in the case of Jordan's Point Park. This is the case of Volpe versus City of Lexington. Opinion from the Virginia State Supreme Court from April 21st of 2011. And we have cites to the case. Official site at volume 281 of Virginia Reports, page 630. You can find the published opinion, or in terms of the West site, West Publications, it'll be volume 708, Southeastern Reporter second series at page 824. Nowadays, most people would use these sites to pull up an electronic copy on one of a number of databases, including LexisNexis or Westlaw. So in this particular case, the Virginia Supreme Court considered whether the city owed a legal duty to warn of a strong current in a mill pond at a Riverside park. And assuming there was such a duty to warn, whether there was evidence of gross negligence under the immunity statute we just cited. Now, not mentioned in this article, but I think it's important and relevant to point out that the Virginia State Recreational Use Statute, which ordinarily would provide that if a landowner opens his land for public rec use free of charge, there's no duty to guard, warn, or make safe, and the only liability would attach where there's gross negligence. A jurisdictional wrinkle in the Virginia statute, in fact, provides an exception which in fact imposes a duty on the landowner of a low-head dam, as we'll see here, a duty to warn. And in the statute, the recreational use statute provides a definition of what constitutes a low-head dam, and we'll see an example of that in the Volpe case. And that nothing in this section would limit the liability of an owner of a low-head dam if he fails to implement safety measures described in subsection F, which requires an owner of a low-head dam mark the areas above and below the dam and on the banks immediately adjacent to the dam with signs and buoys of a design and content in accordance with the regulations to warn the swimming, fishing, and boating public of the hazards posed by the dam. And if you fail to do so, then immunity under the recreational use statute wouldn't apply. But as we'll see, if it's a city or town, then the immunity may still apply, whereby to impose liability there would have to be proof of gross negligence. So that's why we have here the issue before the state Supreme Court, and the facts here, whether indeed there was evidence of gross negligence. In the case provides a description of Jordan's Point and the surrounding park area and facility with picnic tables, walking trails, and a canoe launch. And in the article, there's a link to Lexington, Virginia park site, which includes a description of Jordan's Point. Here, Charles Volpe drowned while swimming below a low-head dam during a visit to the park. Park owned and operated by the city of Lexington. And here, Volpe's parents were seeking damages for gross negligence. The trial court, however, granted the city's motion to dismiss, finding that the danger posed by the dam was open and obvious, and therefore there was no duty to warn. So keeping in mind under the state recreational use statute, which was not mentioned here, in fact, The legislature have imposed duty to warn on the owners of these low-head dams. Was indeed the risk of drowning here open and obvious under the general principles that would apply to a natural body of water not designated for swimming. We'll see the facts here sort of contradict that approach, undercut the holding of the trial court here. And so the issue before the state Supreme Court again was whether the defendant owed a duty to warn invitees of the dangers associated with a low-head dam adjacent to a city-owned Riverside park. Now, the facts of the case in this hidden danger, as we'll see, characteristic of these low-head dams are the powerful hydraulics generated by water going over such structures. So in 1940, the city acquired the Low-Head Dam traversing Jordan's Point in the Maury River. The dam originally was constructed to raise the level of the river, forming a mill pond, so water could be generated to power a mill. By the 90s, the mill had ceased operation, but the dam and the mill pond still remained. And at the time of Volpe's death, in fact, the city didn't even realize that they indeed owned the dam, and as we've seen, may have had a duty to warn, because the dam was part of a larger acquisition of the Riverside property. And Jordan's Head Dam qualifies as one of these low-head dams because the water cascades over rather than through it. And as the water rises, more water flows over the top, the velocity increases, and while the mill pond remains calm, the currents generated by the velocity of the water would not be open and obvious or apparent through the reasonable use of one's senses. And that the pooled water may not appear higher, but the volume of water could be several times greater, producing these, as we'll see, very dangerous hydraulics. So as a result, the presence of this potentially deadly hydraulic, certainly the case with Volpe, may not be open and obvious. And the hydraulic created by the Low-Head Dam, court note, was unusually dangerous because it is uniform across the entire span of the river, where you might ordinarily think towards the bank or the shallow areas might be, quote, safer. So the day he died, April 23rd, 2006, Charles Volpe visited the park with his friend. They planned to swim on to the dam and climb onto it and jump into the water as below, as they had previously done many times without incident. But again, if there's increased amount of water, that increases the velocity that wouldn't be apparent to individuals and would generate these much more dangerous hydraulics. To the boys, Bryce, the survivor, testified that it looked like it did on any other day, that the water was pretty much smooth and flat. And he jumped into the mill pond, and between the tire dock and the dam, he swam over to the tire dock, got out. When Charles entered the river, Bryce jumped in behind him, and they swam toward the center of the dam, and again, the water seemed calm as it did every other day. But then when they got right up next to it, it wasn't until that time they could tell there was a significant difference in the current. They instantly picked up, swept Charles and Bryce over the dam. Bryce found himself spinning in a hydraulic, which he had never experienced, but he managed to escape to shore. And in fact, it is very difficult to escape from these hydraulics. It is quite trap-like, man-trap. Once you get in, you're not getting out. And that's what happened to Charles. He did not escape the hydraulic. and police recovered his body 22 hours later at the base of the dam. Now, defense witnesses testified that they were at the park on that day, and they testified that it had rained several days. The river was high, turned up, and the water was white, brown, muddy, obviously dangerous, contrary to Bryce's testimony that it looked the same as it did any other day, and that they saw that the water was pouring over the dam faster than usual. And then one witness testified that she got in, immediately got out, and at the edge of the dam the water was all white, suggesting a very high velocity, and that the sound of the water rushing over the dam was amplified. And the conditions on that day, she said, contrary to what Bryce had stated, was the worst that she'd ever seen. So let's look at various safety concerns, which may, the question being whether it provides evidence of the gross negligence necessary to impose liability under the state statute. 1997, city officials formed a committee to plan the public park at Jordan's Point. And there were various suggestions, including regaining public access to the water. And the city were planning a place where the people should be able to swim, suggesting that perhaps around the dam site it was an area designated for swimming. And in their master plan, 98, there were some concerns raised by the park's architect about the safety concerns, but they still wanted swimming. And the master plan from 99 regarding the purpose of the park said to provide a place for citizens to access the river. And the fact that people had been using it for swimming, presumably that was one of the purposes for accessing the river. Now, the plan for the park included an existing tire dock 85 feet upstream from the dam for a canoe launch. And the plan was to encourage and provide opportunity for people to swim in the mill pond. And the city envisioned swimmers accessing the water from the tire dock, which is only 85 feet from the dam, and a grassy dam between the tire dock and the dam. So was that exposing them, and be foreseeable that they would access the dam and perhaps go over the dam and be caught up in these dangerous hydraulics. Later on, October 99, a representative from the Small Craft Association questioned the location of the canoe launch regarding the concerns for flooding, and when there would be flooding, it would increase the velocity of the water. And he acknowledged that the currently shown boat launch is not ideal given the dam's proximity and cross currents. So there were concerns from the get-go regarding the location, proximity of dam, and this issue of the currents, which would become greater velocity with more water volume. In 2004, the city manager approached the owner of the property across from the river about running a safety cable from the park to his property, but the city never installed such a safety cable. It's unclear to what extent that would have dissuaded or prevented Volpe gaining access to the Lowhead Dam. 2001, the city submitted a grant application for proposed park to VDOT, Virginia Department of Transportation, and the application stated safety impact that safe flatwater and whitewater canoe launches will be established using previous pavement and other stream back stabilization measures. So this grant that the city received from VDOT for $462,000 was in part to not only create Jones Point Park, but implement some of the safety features that were proposed in the grant application. Despite that, the city didn't move the canoe launch, and more importantly, prior to Charles's death, the city did not take any safety precautions with respect to swimming in the river. But as planned, swimmers visited the park, accessed the mill pond from the canoe launch, and is noted on most days where there was little water flowing over the top of the dam, the mill pond was a placid pool with little detectable current, and that swimmers could climb onto the dam without difficulty, and some jumped from the dam to the river below the dam. So the question is, was this an open and obvious risk, general landowner liability principles with no duty to warn, or was this hidden trap-like where there may be a duty to warn? I already noted that the state recreational use statute, although for some reason it wasn't cited in this particular case, did impose a duty to warn. So in appeal, Volpe argued the trial court had erred in ruling that the city had no duty to warn Charles because it was an open and obvious danger. The Virginia Supreme Court, citing general principles of landowner liability, noted landowner owes an invitee the duty of using ordinary care to maintain its premises in a reasonably safe condition and to warn of any hidden dangers. Furthermore, consistent with general principles of landowner liability, an invitee has the right to assume the premises are reasonably safe unless a dangerous condition is open and obvious. Then there would be no duty to warn. Furthermore, an owner has no duty to warn its invitee of unsafe condition, which is open and obvious and would be obvious to a reasonable person exercising care for his own safety. So moving on, court noted the owner of a swimming pool or lake for which the general public is invited for consideration must exercise ordinary care, which again, the danger of drowning is open and obvious natural body of water, or even man-made once not designated for swimming. But where an area is designated for swimming to invitees, the owner must make reasonable provisions to guard against those accidents which common knowledge and experience teach are likely to befall those engaged in swimming. Not an insurer of safety, but here the question is, was there a duty to warn about the currents at the Lowhead Dam? And in fact, in response to the warnings required under the state recreational use statute of Virginia, there are specific warnings in this area. Conversely, the court acknowledged, consistent with general principles of landowner liability, landowners generally do not owe a duty to warn of natural, ordinarily encountered hazards in a body of water. So would this be natural? In fact, the Lowhead Dam is a man-made structure, and would it be considered ordinarily encountered hazard associated with this Lowhead Dam under the circumstances of this case? The court looked at other examples. Danger of drowning in an excavated quarry was considered natural, open, and obvious, despite sheer drop-offs in such quarry areas. And they noted that the question artificial man-made is, are they any more likely to happen in an artificial pond than in a natural stream of water? So would this open-head dam structure here increase the dangers than you would otherwise associated with a high volume of water coming down the Maury River? So is it a natural, open, and obvious danger ordinarily encountered where people are here children they mentioned swimming or wading? So looking at the facts of this particular case, State Supreme Court noted Charles had the status of invitee because it was open to the public and he entered pursuant to the purposes which the park was open, which included accessing the river for swimming. So he would assume the natural and ordinarily encountered dangers of swimming in the Maury River, as long as they were open and obvious to Charles through the reasonable use of his senses. But was this dam structure, did it constitute an unusual danger, a trap-like situation associated with the hydraulics and particularly associated with the increased water flow here? So, contrary to what the trial court had found, the state Supreme Court here did not agree that this deadly hidden hydraulic created by an unusually strong current at the Lowhead Dam was open and obvious as a matter of law, such that the case should have been dismissed. So while the mere existence of an unguarded body of water does not itself render the owner liable for death of a child who drowned there, but as alleged here, there may be sufficient evidence, as we'll see, for a jury to find if some feature or element of the instrumentality or premises operates as a hidden danger or trap, then liability may arise. And where the landowner or occupier of the premises doesn't guarantee an invitee's safety, simply has to make it reasonably safe, there may be a duty to warn an invitee of an unsafe condition which the occupant knows, here the city, or should know, unless, and this is consistent with the general principles regarding invitee standard of care, wherein the landowner has a legal duty to inspect, repair, remove known or discoverable hazards within a reasonable time. If that's impossible or impractical, or any alternative, provide an adequate warning unless the unsafe condition is open and obvious to a person using care for his own safety. In terms of the scope of the risk, is it what you see or what you get? Or does it appear to be just a placid lake when in fact it's much more dangerous than that? So applying these principles to the facts of this particular case, State Supreme Court disagreed with the trial court, found evidence here might indicate a jury could find the hydraulic at Jordan's Point on that particular day was unlike any naturally occurring feature of a river. And specifically, they noted the increased current above the man-made dam and the hydraulic created below were not always visible to a swimmer and were not always present. So while it appeared, as Bryce testified, that it was the same as any other day, in fact, it wasn't at the time. So unlike a natural hydraulic over a natural waterfall, the hydraulic which Charles drowned spanned the river in a straight line, making escape exceptionally difficult, unlike a natural situation involving some sort of hydraulics associated with whitewater. So as a result, State Supreme Court here determined the trial court had erred in holding as a matter of law that this was an open, obvious danger and dismissed the claim on that basis. So the State Supreme Court stated that a jury should have determined whether the dam in this particular instance presented an obvious danger, where there'd be no duty to warn, or a hazardous trap imposing a legal duty to warn. Moreover, the court had to consider the issue of gross negligence. And on appeal, Volpe had argued that trial court had erred in finding insufficient evidence that would allow the case to go to a jury to consider whether the city had acted in a grossly negligent manner, which would be necessary to overcome the limited immunity available to cities and towns in the maintenance or operation of a recreational facility. And in defining what would constitute gross negligence under the statute, Section 15.2, 1809, State Supreme Court cited a 96 opinion from the Virginia State Supreme Court in the case of Chapman versus City of Virginia Beach, which had defined gross negligence within the context of the limited immunity statute. And gross negligence was defined as the utter disregard of prudence amounting to a complete neglect of the safety of another. So we saw evidence here that the city had done nothing in response to several concerns. So would this constitute a heedless, palpable violation of a legal duty to respect the physical well-being rights of others, of invitees? So was there an absence of even slight diligence or even scant care? And they noticed that several acts of negligence put together could amount to gross negligence and constitute a form of reckless, total disregard, repeated notice of a problem, and nothing done in response. So we've seen evidence already, looking at the facts of the case, to the lack of response on the part of the city here. So deliberate conduct, the court noted, is important evidence in the question of gross negligence. Was there a deliberate decision on the part of the city in planning this park to do nothing to address a hazard known to them which may not be apparent to the recreational user? And the court goes on to describe the Chapman case, in which the city was on repeated notice of a broken gate at a city beach and made the conscious decision to not take any remedial action, to wait till after the tourist season. And then a young girl was hanged on the broken gate, and the court found that this, in light of repeated notices of a broken gate, the conscious decision not to do anything to fix it, was sufficient to constitute utter disregard, the gross negligence as defined in Chapman. So applying that gross negligence definition from Chapman to the facts of this case, similarly, the State Supreme Court found that a jury should have been allowed to determine whether the cumulative effect of all these circumstances described above constituted a form of recklessness or a total disregard of all precautions, absence of diligence, or even lack of even slight care. That's the definition of gross negligence from Chapman. And citing the particular facts alleged the jury should have considered, city manager testified he knew the river could be particularly dangerous in certain conditions because of the proximity to the Lowhead Dam, and could be hazardous even when the mill pond appeared relatively normal. And the director of public works testified he was aware of the existence of the hydraulic during the planning of the park, so they placed the park near this situation. And he knew that the accelerating current at the top of the dam were present in only certain conditions. So the city knows, but that wouldn't be necessarily open and obvious and apparent to the recreational user. He also knew certain conditions of hydraulic would be deadly. And in light of all this knowledge, despite the city's knowledge, the court found sufficient evidence for a jury to consider whether this constituted utter disregard, a want of even slight care. In spite of these dangers prior to Charles' death, the court noted the city didn't take any safety precautions for its invitees swimming in the river. So having found credible evidence where a jury could indeed find gross negligence, the State Supreme Court concluded the trial court had erred in dismissing the claim without a trial. So as a result, State Supreme Court here reversed the judgment trial court and sent it back for further proceedings. And on remand, sending it back, a jury would indeed consider whether the city had a legal duty to warn. And there, the language you cited earlier from the state recreational use statute would certainly suggest that there should have been a legal duty to warn with this type of dam structure. And if so, was the failure to warn, was it sufficiently egregious that it goes beyond mere carelessness, that it demonstrated the utter disregard necessary to show evidence of gross negligence to overcome the statutory immunity for cities, towns, counties in the operation and maintenance of public recreational facilities. So as mentioned, this particular article was published in April 2012, and we go back to April of 2008, I believe, and had a similar case. It was reported that the State Park drowning machine. There, a New York Court of Claims, applying the same sorts of general principles, similarly found that a fatal whirlpool was not open and obvious, and therefore the state of New York may have been liable. However, after reporting this case on appeal, a subsequent case, the idea whether it was a latent danger or what have you, and whether the individuals had assumed the open and obvious risk, and they said, well, if it was hidden, it wouldn't be considered an open and obvious situation. Later on appeal, Cohen versus State of New York, this particular court reversed the decision of the claims court and found indeed that this whirlpool situation was considered an open and obvious danger associated with swimming in that particular body of water. Now, it's different jurisdictions, so you don't have to necessarily reconcile the two, but it shows you two different views. And how could you distinguish one from the other? You might say that unlike a popular swimming hole in an Adirondack State Park, you had this man-made structure, the dam, in the Volpe case. So maybe the circumstances, the proximity and the like, you could distinguish the two, or just effectively say, well, there's two ways of looking at this thing. One, it's open and obvious. On the other hand, it could be unusual or trap-like, where there may be a landowner duty to warn. Now, going back, we look at the course in the material linked to this particular material. There again is the Virginia Recreational Use Statute, the duty to warn for Lowhead Dam from the State Recreational Use Statute, and a link to the Recreational Use Statute itself. But also put in a link regarding Lowhead Dam risks. And I think this is interesting in that it's the Virginia Municipal League insurance programs, and it describes the hazards associated with Lowhead dams, and there's some illustrations of what might constitute the warnings. You see the signs at this dam, the buoys, all seemingly consistent with what's required under the State Recreational Use Statute regarding Lowhead dams. And in fact, the signage goes on and it describes hazardous recirculating currents would cause the drowning of a victim. And in fact, They even mentioned the Virginia Code section and the like, which were discussed in the previous article. So that's all the time we have for today. It gives you another idea of not only general legal issues in recreation administration, but particularly recreational injury liability, and another example of limited landowner liability, limited immunity for public entities. We saw an example of the Virginia statute where there won't be liability for ordinary negligence, only gross negligence. That's fairly typical of how these immunity statutes work. But in addition, we saw what would be the definition if you're not liable for ordinary negligence, only gross negligence. What would constitute gross negligence? And in the Volpe case, there was enough evidence put forth by which a jury could find gross negligence and impose liability on the city. So this is Professor Kozlowski, and we'll hope to see you next time.